So thank you again for being here. And just another reminder, fill out your CLE form and leave it in the middle of the table. Don't take it with you. Just leave it in the middle of the table so we can pick it up. Also, there is a reception afterwards, right afterwards at 4:30. We have a lot of wine, cheese, etc. So please don't leave without at least taking a glass of wine. So we're going to explore here. We're going to start with sort of what happened during COVID in family court, New York City family court, and why. And I think the why is critically important because COVID didn't happen in a vacuum. COVID laid bare inequities that were in the system for decades. And I think it's an interesting inquiry. We're going to talk about the court structure, the unique, antiquated New York State court structure that no one would design, and how that impedes access to justice. And then we're going to talk about some specific recommendations, legislative recommendations, focusing obviously on domestic violence. And if you have any questions, obviously someone should just let me know. Happy to include them at any point. All right. So no long introductions. Karla George, Deputy Director of Family Law Project, Sanctuary for Families. Christine Perumal, Director of Safe Horizon Domestic Violence Law Project, Safe Horizon. Denise Kronstadt on the very end, Deputy Director of the Fund for Modern Courts. Full disclosure, I am the chair of the board of the Fund for Modern Courts, so Denise will get a disproportionate amount of time to speak. And Joan Gerhardt, Director of Public Policy and Advocacy, New York State Coalition Against Domestic Violence. Christine, let's start with you if you don't mind.
Sure.
I'd like to, again, explain what happened during COVID in New York City Family Court. Let's focus on Safe Horizons caseload. The court pretty much shut down for a large percentage of cases for an extended period of time. Talk about your experience, talk about your group's experience at the beginning and middle of the worst part of COVID.
Sure. So good afternoon, everyone. It's great to see you all today. So I'll talk a little bit specifically about what we saw internally in our program and the effects that the pandemic had on survivors that we serve. What we saw was troubling, right? The pandemic exacerbated many of the issues that survivors face on a daily basis. Karla will go into this a little bit more, but what we struggled with was the ability for survivors to get into court, number one. There were certain matters that were deemed essential and non-essential. And what we saw was clients calling our internal helpline, asking for things like child support, which during the height of the pandemic was deemed non-essential, a non-essential matter.
Let me stop you right there. So the court makes this distinction between essential and non-essential. Let's define our terms. So what was considered to be essential?
So Karla, do you want to get into, I know that's part of yours. Sorry.
Sure. Once again, good afternoon, everyone. And it's very great to be here. I actually, in preparation for this panel, went through all of my notes for the various meetings that I was involved in involving COVID and the new protocols. And I have here in bold and exclamation marks that what was deemed an emergency was life or death. And that was blatantly said and put into a clerk's hand to determine what was life or death.
Right. So proceedings like orders of protection, child protective delinquency generally was considered to be essential. And then non-essential support, visitation, custody, adoption, guardianship. But within that world, there were some so-called emergency cases, and I guess this would be for both Karla and Christine. How did the court determine when custody, visitation, support, adoption was essential or non-essential?
Well, I think there was a lot of discretion given to these judges, right? And so we had child support matters that would come through our internal helpline, clients wanting to file for child support in very dire situations, right? During the height of the pandemic, people had lost their jobs. Some survivors had even left the home and inquired about getting financial support. And when we told them that there really isn't an ability to file for even child support right now, some people said to us, well, then I guess I should have stayed. I should have stayed. And you've heard the troubling stories today. And we heard some troubling things that survivors experienced at the hands of their abusive partner. And to think that a survivor would go back to that point to say, I should have stayed was very troubling to hear. So um, unfortunately, during a time period, there wasn't a mechanism for litigants to be heard. They could send their petitions and they would eventually, to our knowledge, be calendared at some point in the future. Um, in terms of visitation cases, we had many cases come through our helpline where survivors had left their home and their child was still with the abusive partner, and there was no way for them to really get in, either through a writ. Maybe their writ was denied, or they couldn't get in through an order to show cause. And their visitation petition still was deemed non-essential, and so they would have to just wait until that was calendared. And we'd had cases where there was months, 4, 5, 6 months of time passed between contact with a client and a child. And in a young child's life or any child's life, that feels like years. So really, during the height of the pandemic, there was really no mechanism to get in unless you fit nicely under those categories. And if you filed an order to show cause and the court deemed that it was a true emergency and it was life or death, or that a child's life was in danger, you could possibly be seen by a judge.
Yes, and to add to that, just taking a step back, when going into family court, someone is already deemed that it is emergency to them. So that's why they're there. They're part of a broken family. That's why they're seeking help. And so then when you say this has to be life or death, to some of these people, this is. And one example that I had, we also had a hotline and the numbers went up very high right after the pandemic hit. And a woman called and I screened her, which is like a consultation. And the abuser kept both of her children. There was a boy who was around 9 and a girl who was around 13. There was a custody order. The mother had custody and the father had already a finding of neglect against him. She called ACS. ACS refused to get involved. They would not remove the children. They said it wasn't an emergency. So she called our office and I said, this seems like an emergency. Let's see what we can do. In between that time and trying to get an attorney to help her further, she called me and she said, he's returned my son, but he won't return my daughter. And my daughter keeps texting me, telling me that she doesn't feel safe, that she is having suicidal ideations, that she really wants to come home. I've called ACS and they refuse to do anything. At that point, I filed an order to show cause and I sent it over to family court. Unfortunately, we couldn't take this case because we had already had all of these cases that have been sitting with us pre-COVID that weren't going anywhere. So we were at capacity. So now I'm helping this woman on a pro se basis. We filed an order to show cause. I thought it was an emergency. I'm sure many of you thought it was an emergency, but the clerk didn't deem an emergency. So this woman could not get access to her daughter that was held with this abuser who had a finding of neglect against him. And unfortunately, I don't know what happened because part of my job and the hardest part of my job during COVID was saying, no, I can't help you. There's nothing else I can do. And after hearing that, of course, there was no follow-up from the client because what could I do? But that was a prime example of what was life and death to somebody that wasn't life and death to a clerk.
And just so people are clear, pending cases were frozen, cases pre-COVID were frozen for about 9 months if they weren't considered emergencies. And new cases that were submitted to the extent they were allowed to be submitted during COVID weren't calendared until the spring of 2021, so a year after COVID started. Christine, do you have any specific example of a case where there was significant delay in a so-called non-emergency case?
Well, unfortunately, I have many, but what I saw I just want to highlight something before I get into that. What I saw was another issue during the pandemic was clients whose primary language was not English, right? Or who had limited proficiency. And the language barrier um, exists we always are grappling with language barriers and clients who don't speak English and trying to access the courts but not understanding how to navigate the courts. And that was exacerbated during the pandemic. Clients who didn't speak English didn't know, they would show up to the courthouse, we would get calls and they would say, what do we do? Like, how do we even contact anyone in the courthouse? Then we'd have clients who would have a friend or a neighbor send paperwork to an email address that was designated in each borough to the court. And then they'd receive correspondence back and couldn't read it. Some clients were missing court dates. Some clients didn't know how to sign on or click on a link to use the technology. These are just huge barriers that have existed for decades and they still exist. And I'll get into that later about recommendations, but yeah, there were a lot of delays. Specifically, one example, there was a child safety concern where we filed an order to show cause on a pending custody case. And it took the court about 4 weeks to schedule the order to show cause. 4 weeks on what could have been a life or death situation for a child. And when we followed up, we were told that there was limited capacity. This judge didn't have a court attorney, and that we should check back in with the petition room. And this, as many of you know, as practitioners, this is just not a normal course of how you deal with an order to show cause that you filed. And so it took us about 4 weeks to get in on an order to show cause. And then the matter was adjourned for another 3 or 4 months.
And in terms of language, there was a sign on the door in the family court in English. Then they added English and Spanish, a sign on the door. And if you go on the website, limited number of languages. So I think that's a point well taken. So Christine or Karla, so family law pretty much shut down for a significant period of time, but family law matters were litigated in the Supreme Court at the same time. Is that accurate? What's your experience?
That is accurate. And in fact, that was part of our strategic planning when screening or consulting with a client, whether we would want to send them into Supreme Court where they weren't guaranteed an attorney free of charge or there were filing fees that they couldn't afford, but that was your quickest way to a judge. Otherwise, they would have to wait for family court to even docket their custody visitation or child support petitions. And you only have that relief in Supreme Court if you are married. And maybe some people do not want to move forward to a divorce, but they wanted the child support, they wanted custody. So we did have to battle that, and it was very hard to explain that to clients that one court was open and able to receive orders to show cause issues, and one court was not, and why was that? And I just did not have an answer.
And so when Jay Johnson is talking about a second-class system of justice, this is the best concrete example when one set of justice for those who are married, have a lawyer, can afford a fee, those matters are going forward. Whereas for people who are predominantly poor, people predominantly of color, those matters are just put on a shelf and deemed non-essential. Notice how, as a moderator, I stay completely neutral in my questioning. So we'll move on, but I also want to know a little bit about why the difference between the outcome in family court versus the other courts in the state. What was it about how family court operated pre-COVID that sort of guaranteed this result? And I won't say Christine or Karla, however you'd like to divide it up.
I mean, I think it's lack of resources, right? The court just was not set up to deal with the pandemic, as we all know. We went in and we paper filed our petitions, and that's how we got into court. And then when the pandemic hit, we just didn't know how to operate, right? We couldn't go into the courthouses physically. There was no e-filing system set up like in Supreme Court. And so that was an access to justice issue, right? There was just no mechanism in place for low-income populations, Black and brown communities to get in. And that was the reality of it.
Sure. Family court has always been deemed the poor people's court. And so when you are balancing out the funding for a court, are you going to put that funding into Supreme Court where they're litigating civil issues, where there are justices sitting there instead of referees and support magistrates, where you have people that are litigating cases that are worth millions of dollars? Or are you going to put the resources into a court where there's institutional bias that's already built in? So as Christine says, the writing was on the wall. Just not having an electronic filing system until COVID, and the one that was produced, which was entitled EDDS, that wasn't even an electronic filing system. It was a place to hold the documents so you would feel good that the documents went somewhere. But things like that, where the writing was already on the wall, that is why family court shut down, because they were just incapable of making a quick change into a virtual environment.
So if you look at family court when COVID began, it was much like it was in the 1970s or the 1960s. If you wanted a document, you go there in person. You had to file it in person. There were staffing shortages. There weren't the capacity for virtual proceedings. Staff members couldn't work from home. Now I'd like to segue into sort of what are the consequences of sort of this happening. So let's start with child support. Generally speaking, all right, so someone doesn't get money, but what are the real consequences of the people in family court who have to go extended periods of time without getting child support?
Well, it's really, can I afford to buy groceries? Can I afford to buy diapers? Can I afford to just meet my basic needs? These are the individuals who are coming and accessing family court. They are from low-income communities. We already know that the docket is disproportionately made up of Black and brown families. And these are the real consequences. Can I eat tomorrow? Can I feed my family tomorrow? And, I circle back to just, hearing not just one survivor say this, but a few say, well, if this is the consequence of just me not being able to file, I should have just stayed. I should have just stayed so that I could guarantee that my child could have food tomorrow.
And Karla, custody or visitation, when a case sits for 9 months without moving, what are the potential consequences?
I mean, we've heard it here through all of the powerful speakers. There's the thing that hits me most is when Stephanie McGraw spoke, we're looking at femicide. We're looking at child abuse. We're looking at maltreatment of children. These are abusers that have these children sometimes in their care. And COVID was a perfect storm for that. Oh, you work in healthcare, so I don't think the child should be with you, so I'll keep the child. Or, you're not home all the time, or I'm home all the time. Whatever the excuse was, it was the perfect storm to keep these children. And then when you have a custody visitation petition that is pending for months at a time, you are at risk of the worst case scenario being femicide.
So at some point, the court was able to introduce virtual proceedings. It was a little bumpy. We won't get into too many details on that. I'd like to bring in Joan, however, to talk about how virtual proceedings relate to domestic violence and what your views are in terms of how it's worked and what your recommendations are going forward.
Great. Thank you, Bill. And thank you, Sanctuary, for having me here today. These aren't really my views. At Initiative, we did a number of conversations with advocates and attorneys around the state to really look at the practices that were put in place during COVID and what was working. And we might want to consider advocating for long-term implementation versus, what we really didn't want to go near, right? Didn't want to see continue. And I'd say overwhelmingly, not just from advocates and attorneys, but from survivors too, We heard of the benefits of virtual proceedings, for all of the reasons I think we all know, right? You don't have to go to the courthouse, which means you don't necessarily have to take a day off of work. You might not have to figure out childcare, since you have to sit there all day. That's a lot of money, coming up with childcare. It's much easier, to just tap onto a computer and get online. So I won't go into too much of the benefits because I think that's pretty much well known. But there was a lot of concern about if we were to institutionalize virtual proceedings, what that would really look like statewide. Because we know from an equity standpoint, from an accessibility standpoint, and from a connectivity standpoint, there is not equality statewide for these things. Not everyone has a laptop or a fancy phone where they can access a virtual proceeding. And what I heard overwhelmingly from advocates and attorneys was how they had become essentially tech support for their clients. So either clients had to come into their offices to use their technology, or maybe they had to go where the client was to walk them through getting online. The instability of being potentially at a public location in order to get a decent signal to get onto, the court proceeding. So all of these things I think have to really be taken into consideration, particularly when we have 2 million people in New York State who don't have a solid connection. That's 2 million people around the state. I think it's probably more. I don't really know how they come up with those estimates, but we really have to think about those things. We have to think about funding to make sure people, advocates, attorneys, if this is where we're heading, that we have safe spaces and we have the technology for clients to use that technology. There's a lot of inconsistency statewide on the use of virtual proceedings. So without question, we need consistent approaches to how technology will be used for virtual proceedings. We have to be able to say to parties, if you're in a proceeding and we start virtual, we're going to continue as virtual. If we start in person, we're going to continue as in person. And I'd like to see a day where the parties are actually electing. I mean, I know in domestic violence cases that might be difficult to get an agreement, but to say, okay, we want to have in person or we want to have a virtual proceeding, it shouldn't be up to the judge's discretion, just sort of a willy-nilly approach. So people don't know what to expect when their calendar date is coming up until maybe a few days before. And oh my gosh, I actually am in person this time. Now I have to get out of work and arrange childcare. So those are really big issues. I think we also need to provide training for judges on technology, because there's inconsistency with what the parties see when they participate in a virtual proceeding. Sometimes they see the judge. Sometimes they see the person who's speaking, not always. I think most often they don't see the other party. They didn't see the abuser, but I'd like to see that in protocol, that they don't see their abuser during virtual proceedings. I think that's very important. And even maybe constructing safe rooms in courtrooms, right? We heard about the condition of some of our courtrooms, which is horrifying enough. But maybe we go back to the days when we had safe spaces in courtrooms where survivors could go and even appear virtually from the courtroom. So they don't have to be in the physical presence of their abuser. And the final point I'd say, Bill, is that I think there has to be a panic button. There has to be either a phone number where someone is actually sitting at that phone, or an email where someone's immediately responsive if there's a party who can't access a court proceeding when it's ongoing. To Christine's point, I even heard of a story of someone who spoke English as a second language and didn't understand the prompts to get into her virtual proceeding, and the case was dismissed because she didn't appear. We can't have that happen because of a problem of technology. Cases can't be dismissed. So we have to have a way to communicate with the court if there's a problem accessing the court proceeding as it's happening.
Thank you. Before we move on, I want to hear from both Christine and Karla, just in terms of how you think virtual proceedings are going and whether you advocate for uniform rules, whether it should occur or how it should proceed.
So as far as the virtual proceedings are going, our clients benefit very much from it. And I say that because of some of the things that were just stated, and that they don't have to take off a day from work. They don't have to find childcare providers. They don't have to travel far distances, because some of us work with survivors that are no longer in that borough. They've moved to a safe space, and they have to travel back to that safe space. Back to the borough where the case is being heard. And the things that are fallbacks are some of the technology issues. So we do have clients, and we've had clients throughout the entire pandemic come into the office if they did need that assistance. Some other fallbacks is that things that I have personally seen is the opposing party reading when they're testifying, which they're not supposed to do. Somebody being in the room recording something, and then it's publicized. So then we started getting the prompts that it can't be recorded or publicized. So as we went into the virtual proceedings, we found more issues with it. But in my opinion, it is better for our clients, survivors, and victims both to have those virtual proceedings.
And I'd have to also agree. I think overwhelmingly our clients prefer the virtual proceedings. I think that it's just a different space, right? Survivors, I know our clients get really nervous when they have to appear in person in a very tiny space with their abusive partner, and it could affect their credibility, right? It could affect how they present in court. And a lot of that is taken away. A lot of that stress is removed when they can just appear virtually or put a post-it note over the abusive partner's picture so that they don't have to see him or her. So I think that it has its benefits. I think that, yes, we should have unified rules so that we know what to expect. Clients know what to expect, attorneys and judges. So we're all on the same page. But I think overall it works. I think where we get into a bit of an issue where it could work, and that's to Joan's point, is to have more training and technology is when we have trials and the different evidentiary issues that come up.
And I'm sorry, I just wanted to comment on the uniform rules. This is one of my pet peeves. New York City courts are unified court system. So to even ask that question is, it's one of my pet peeves. So yes, we should have unified rules across the board. And I've been advocating for that. Have them posted, have them circulated so that not only I, as an attorney that's been practicing 10 plus years, know how to go into one part and knows what expected of me, but also the pro se litigants.
Yeah, and the reason I asked that question, by the way, is that there is enormous resistance to uniform rules within the court system. Some judges take the position that they interfere with their discretion. Of course, we're not interfering with any decision-making or any substance. We're simply giving litigants the ability to know what to expect when they walk into a courtroom and not to expect two different things depending on which judge that they get. So we've established that the family court is treated as a second-class system of justice. We've established throughout the day that family court judges are considered less prestigious because judges want to be Supreme Court justices, because they want to get on the appellate division, because there's greater status. And so that essentially the system values a contract case over a case that determines the safety and security of families and children, which seems to be completely messed up. Denise, the Fund for Modern Courts has been advocating for court reform, restructuring the court system. Why is New York's court system, the structure itself, an impediment to access to justice? And one of the reasons why we're talking about the family court the way we are. Sorry for the compound question.
Thank you, Bill, and thank you everybody on this panel and everybody here. It's very inspiring to be here with the work that all the organizations in this room and streaming do. For many years, the Fund for Modern Courts and actually everybody here has joined coalitions to try to change the structure of the New York State court system. And if you look on the screen in the room, and I believe the screen also streaming, you can see that it's not normal. You know, that in New York, we have 11 different trial courts, 11 different trial courts. And in California, they changed that, what they had in the late 80s, and New Jersey also. These are two examples. Why we have that is history, right? This is just things that were created over time. And like so much else, it no longer functions. And it actually is dysfunctional, and it actually perpetuates the inequality we have in our system, the biases we have in our system, the prejudices we have in our system, but we can't seem to change it. And we can't seem to change it because we have to amend the Constitution of the state in order to change it. And there is a lot of interest within the political system to keep it the way it is. And that's all determined by who appoints or who elects the judges within that system, okay? So in order to try to change it, everybody in this space, in the same way you do all the work you do, would have to work together to really make the change. As a practitioner, formerly myself, not a family law person, but I did tenants' rights. When you're practicing, your focus is always on what you're doing in the day-to-day and working within that system to ensure that your clients are getting what they need. So it's sometimes hard, and I'm not saying this is true of people in this room, to understand that this is just really irregular and it needs to change. So the concept is that we would take, and in the booklet, you'll see this, the images. We have these great images by this great illustrator, editorial illustrator. We would take the city court, civil court, criminal court. No, I'm sorry, let me correct that. We take the district court, which is in Long Island, civil court of the city of New York, criminal court, and make that into one municipal court so that you can go there for those variety of issues. And we would take the family court, surrogate court, county court, and court of claims and Supreme Court, and make that all one superior court, which is like what they have in California. I have two cousins married to each other, both judges. One is now a federal court judge, judge in Superior Court. They've heard criminal cases, they've heard family cases. They sat in the commercial part. They do it all.
So let me stop you right there. What would be the advantages of having the family court essentially being the same as the Supreme Court, merging it and calling it, you know, the Superior Court? What are the advantages?
Well, as we know, the Supreme Court does have the jurisdiction to hear family court cases, but they don't, right? Or at least I know that's outside of the city of New York. The advantages would be numerous. One would be that resources wouldn't necessarily be determined based on what that court was. You'd have to equalize these resources because the resources are all going to the Superior Court, number one. Number two, which is issues I'm sure everybody in this room experiences, and we have numerous examples. I just want to give a shout out to Kim Susser, who helped me draft all these examples, and others in the room, is that people wouldn't have to be going to a variety of courts in order to have their cases heard. And, you know, it's not just about that you physically have to go to different rooms or different buildings. It's that you're going before different judges, and you might be represented by different attorneys, as well as your children might have different attorneys, and none of the cases get integrated and heard as one. I mean, how foolish is that? So the advantages for these cases is you'd be integrating the various issues, and you'd also hopefully be able to ensure that resources were more equally distributed.
I kind of interrupted you, so you can.
That's okay. I'm used to that. So I just, just to explain it a bit, that New York has the largest court system in the world, apparently, and yet we're the least streamlined. We have more trial courts than any other state in the country with 11, and we have charts in in your materials and also online that you could see about that. And that having so many different trial courts might sound like a system that specializes, but it really doesn't. And what so many different trial courts do is create exhausting, chaotic, confusing judiciary that, despite the best efforts of many here, many within the system, cannot provide the best possible justice, not just us, justice. So the way it's seen is that who would be impacted? Any unrepresented individual with few, if any, resources who faces a system they simply do not know how to navigate. Survivors of domestic violence who must make frequent court appearances in multiple courts for interrelated issues, having to retell their story of the violence they experienced. People in criminal court, housing, or family where court calendars are overloaded. Families burdened by having to appear in multiple court venues, being represented by different lawyers, which I just said. People losing wages and work. And then there's also these benefits to businesses potentially. They'll do fine. Individuals with disabilities who face additional, often insurmountable challenges, and just the state itself would be greatly benefit by a judiciary that we're not always working around the edges to make it work, that we can potentially do this. Now, this is very grandiose what I'm saying. So I think that the resolution that's been proposed that hasn't moved would have a 5-year implementation period if we could get this passed. And it would be my belief, and I believe the belief of the Fund for Modern Courts and members of the coalition, that all the stakeholders here should be a part of what the redesign would be. But we're having such a hard time getting to that place, but that should be part of what it is.
So, sorry to interrupt again.
Mm-hmm.
During COVID, was there a bailout of the family court by the legislature and the governor? Did they take any measures to improve what was an extreme and critical situation?
Well, maybe Joan could speak to this too. I know that there were more family court judges added.
How many family court judges were added to New York City from the beginning of COVID to today, if you know?
I don't remember the number, Bill. Four.
How many Supreme Court justices throughout the state were added during the same period?
I believe it was 14.
It's about
20?
over 20.
Right.
And these are all leading questions, I guess. Did the legislature consult the court system before deciding to spend the money on over 20 Supreme Court justices in places where they weren't really needed?
The answer to that question is no.
Right. So we can focus our criticism on the court all we want, and I've got plenty of recommendations. But I don't think we should lose our focus on the other two branches of government, which have completely dropped the ball and have completely been indifferent to the hardship of real people who have not been able to seek justice in court. And so I think it's important, whether we try to amend the Constitution or try to do anything else, we need to increase the pressure on the legislature and on the governor to actually do something. Our entire legislative agenda failed. And it failed out of indifference. There was no very few substantive arguments on the other side of these issues. We have a question from the audience. And this has to do, I think, consistent with other questions about how good things can be used by bad people. So in terms of technology, are you aware, any panelists aware of situations where abusers have used the enhanced technology of family court to their advantage, either by delaying proceedings or taking advantage of the other side because of technology?
Yes, I can speak to that. There have definitely been blatant delays of claiming that they don't have technology when our clients have stated that not only do they have technology, but they're well informed and they know how to use it. They just do not appear. And because we have this virtual proceedings, the jurors will give them another time to appear because they're not sure whether they are not getting into the room. They had issues with Microsoft Teams earlier in the day, so we'll give them another shot. But the instances that I have seen are, in my, once again, humble opinion, delays that are purposely for the reason of protracting the court appearance or the court case.
And I guess the same. I think one thing that I see often is that the opposing party decides to keep his or her camera off, and that also throws off our client when our client is trying to do their best to participate and be fully engaged in the court proceeding and taking it a lot more seriously. And is a very difficult situation to be in. And you just see the harming party just not turning on their camera or having mic issues or tech issues. That probably really aren't real issues, and not much, unfortunately, being done about that.
Denise, we have a question for you from the audience, which has to do with whether if we were to consolidate the courts, whether one judge would have the expertise to handle divergent practice areas, or whether it would be structured in a way so that judges would still have some specialty.
So the idea behind the resolution to amend the Constitution so that you restructure the court system would be to have this 5-year implementation period, which I mentioned. And there is often fear that judges in the system, which I think was even addressed within the family court before, may not have the expertise or care or knowledge to know what the issues are. This is actually a real concern. So it would really be up to all of us to address that during this implementation period. I'd like to say that the way that this resolution is designed is to, and some people say, well, if you're going to have parts, what's the difference? Well, there is a difference because it'll all be part of Superior Court or Supreme, whatever they end up calling it. You would have parts. You would have a family court, family law part. You would have a commercial part. So initial stages would be, there would be expertise. But what other states have found, and I'll use California as an example, is that with time, you change culture, we hope. And that means that people coming into the system know that they're going to have to sit in family court cases, will potentially have more of an interest in doing that. It won't be just like, I'm going to Supreme, I'm just going to have torts and commercial cases. I know that I'm coming up through this and I'm going to have that specialty. So, and just to add to that, if it's okay, Bill, I just want to make this one point about in New York State, and knowing how the structure works is sometimes very difficult to believe. But in New York State, the only judges that can get appointed to the appellate division are judges from the Supreme Court. So family court judges or county court judges outside of the city of New York, surrogate and others cannot go to the appellate division. If you were to have this unified, more unified court system, where hopefully they'd have unified rules and unified forms, if you'd have that, all those judges in there who are coming with different expertise would then be eligible to be appointed to the appellate division. So these are cultural shifts that would take a really long time to happen. So, I understand the concern and I agree with it, but I think we can't get bogged down in that because we're looking towards the future of making certain changes.
So I want you to address, if you would, Denise, court monitoring. Before we get to that, there's one other issue that I think is driving injustice in family court, and that is, put aside the constitutional amendment, it's just the lack of judges. And having to borrow judges on a short-term basis from other courts. And so there's this revolving door of judges and inherent delays. I'd like both Karla and Christine, I know this from more of an academic standpoint, but how does this sort of revolving door impact real people?
First, I would like to say that when thinking about the training for judges and the cycling in and out, what I thought about was attorneys are trained in a specific area, and we are trained for many, many years. And if we dare take a case that's outside of our expertise, we are held responsible for that. If we mess up a case, or if we don't know the law, if we come in and we don't know what we're doing, we are held to a certain standard. So to me, it seems unjust to have judges cycling in and out and going to these different court parts, going to these different courts with having what I feel is minimal training in what they're doing. And so not only does it cause delays because you have one judge and then 2 months later, because they've moved back into the civil part, then you have another judge, so that judge has to be caught up to speed. I mean, we've had cases where we've been in front of 3 to 4 judges, and every time that judge has to be brought up to speed. So we'll have a case on for trial with a new judge. I know it's not going forward, but is the judge going to tell me that? No, I have to wait until that day. I have to prepare my client, and I have to say, well, we're on for trial, for the judge to tell me, well, I've just gotten this case. I don't know what's going on. I need the court minutes. And so it just protracts the case. It's not justice for anyone.
And I'm going to just echo what Karla has said. You know, we've had cases, especially over the pandemic, where we've had 3, 4 judges on a matter. And yes, they have to get up to speed. And some of these cases are at trial posture. And we have had our preliminary conferences, our settlement conferences, and then we get in front of a judge and we're ready for trial. And they say, no, let's try to settle this. Let's have another settlement conference and let's adjourn it 4 more months. And it's not justice for families. It's huge delay. It's re-traumatizing the children and the parties in court.
And
yeah,
I'm
please.
sorry, I just wanted to add to that. When we're spending years in court, the posture changes. And so the abusers have an opportunity while they're under scrutiny to change the way they act. And our clients, they get these bad decisions and saying that, well, you've had an order of protection this whole time, so nothing's happened. So why do we need to go forward? Let's settle that. Can we just, withdraw those petitions? And that's because it's been 3 or 4 years going through different judges that didn't hear the initial testimony, that didn't see that litigant testifying and being distraught. And so they don't understand how important it is to come out of that and have that final order of protection, or have a custody visitation order that actually is helpful for the clients and will not result in them coming back to court. But the posture changes so much over those years, and sometimes it becomes an imbalance.
And when you have a case where you might have, you said 3 or 4 judges on the same case, I know this is sort of an unfair question, but typically how long would a case like that take to get through from beginning to end?
So I have a very specific case. We started off with ACS, and then we went into the order of protection case, and then we went into custody and visitation. And in that case, I'd like to highlight that my client was on the stand for approximately 6 months because of the adjournments. And one thing that lay people may not know is that you cannot talk to your client while they are on the stand. So 6 months of my client being on the stand, and I can't have a conversation with her about what is pending, about what is really going on. And so for those cases to resolve itself, it took about 4 years. And my client started off in a domestic violence shelter. And by time we were finished with the case, she was a physician's assistant. She had went to school. She had moved to a whole different borough. Thankfully, the posture changed in our favor in that case, but that's just how long it took.
And over the course of those 4 years, do the children stay the same age or do they get older? So let's move on to court monitoring. Let's move on to some recommendations, one of which would be court monitoring. And Denise, if you could just briefly describe sort of a project that you, I know, are working on that may, if other people are interested, we may want them, if they're interested, to be involved as well.
Thank you. So I believe that court monitoring historically started with domestic violence cases. That's where it kind of began, so that people would go into courts to see what was happening. So that seems to be the origins. And of late, there haven't been that many court watch programs in New York, except there is one in criminal court. I worked on one in Rhode Island with Everytown for Gun Safety on relinquishment of guns and domestic violence cases. We worked on court watch up in Warren and Washington counties in New York, and also out on Long Island in family court. And I thought, as complicated as it is, as hard as it is to make a court watch program actually provide accountability, as well as people that come in to see what happens, I thought it might be time to do it. And I would be happy, with the permission of my board chair and others on the organization, to kind of help facilitate a court watch program in family courts. And Her Justice has done an excellent job on support proceedings. Modern Courts had a little role in the initial stages of that. So if organizations are interested, and I thought it could be a collaboration. The other thing with court watch is it's often perceived as bring neutral people in. I don't really know why you have to do that. You know, I believe you bring in like Stephanie McGraw's group, or people that really are invested and understand the system and understand the problems, because so much of it is about procedural justice. It's hard to see what the result of cases are unless you're following a case. So, so court monitoring traditionally engages the public. It educates people about it. It builds relationships between the courts and the public and the stakeholders, and it could potentially provide information for advocates. So it's just it's like a germ of an idea, but I just think it might be something we could all consider to do, with Modern Courts helping to facilitate.
Let's not use germ analogies.
Oh, well, that was a virus. Not a germ. So, so yes, that's what it is, and it has value, but it's a difficult process to do, and it's a difficult process to establish the value on the other side of it. Am I correct, Rachel? It's very hard to do, but also very, very important. So
Great.
Yeah.
Joan, I want to sort of end this with you. So you're the only thing keeping us from some wine. So
What do I have, an hour?
let's talk about your legislative agenda. There's about 20 pages worth. Let's just focus on the key measures in terms of domestic violence, what we want to get accomplished in the next legislative session. Maybe talk a little bit about the use of forensic studies, or using domestic violence as a factor, whatever your group thinks are the top priorities.
Yeah, well, we're still framing our priorities for 2023, but top of the list will be Kira's Law, which Jacqueline Franchetti talked about this morning. Niskative has been advocating for Kira's Law really before it's in its infancy, before it was a developed bill. And we feel very, very strongly that this comprehensive legislation will move family court forward because of that expedited emergency style hearing that would happen in the first instance to take a look at the safety and well-being of children. So not a full best interest factors evaluation, which takes many, many months, but just looking at the child's safety. And the court could then order an emergency temporary order, which it already has the ability to do, but rarely does, to ensure or at least enhance the safety of that child. And then the court can do what it does over many months, unfortunately, but look at that full best interest factors evaluation. And the other important thing, other than the judicial training Jacqueline talked about, that the legislation does is it talks specifically about parental alienation and friendly parent. And it says to the court, you cannot consider whether one parent is a friendly parent to the other. You can't consider whether one parent is alienating, because we know courts get that wrong, right? They get it wrong all the time. So we're just saying, take it out. You can't do it. And there's a rebuttable presumption that if domestic violence, if one of the parties has perpetrated domestic violence, then the court cannot order sole or joint custody to that abuser. So it's very, very clear. So if you haven't seen it, take a look at it. I can give you a copy of the bill. It's really great. With respect to forensic evaluators, we talked about this too a little bit earlier. We were honored to participate in the Blue Ribbon Commission on Forensic Evaluations, which had 11 specific recommendations for the use of forensic evaluators in family court. There's been several bills that have been introduced in the Assembly and Senate as a result. There's a bill to completely eliminate forensic evaluators, which, you know, I've heard judges say, how could we possibly do that? Well, we never used to have forensic evaluators, right? They weren't always part of the court process. In the 90s, we didn't have forensic evaluators. Now, certain judges feel like they can't do their job without them. I challenge that, because judges make decisions every single day, every hour that they're sitting on that bench. They don't need a forensic evaluator telling them how the parties parent. If they need someone to assess the mental health capacity of a party, they can bring in an expert witness to do that. They don't need a forensic evaluator. And I think the issue comes back to resources. If we had enough resources in family court for judges to really take the time to evaluate the parties in the litigation, we wouldn't need forensic evaluators.
It's a shortcut.
It's a shortcut. Although it takes many, many months to get
It's a
your
long
forensic-
shortcut. But what are the chances of that passing? Or I know that's an impossible question, but is that something that you think we can actually get done?
I think it needs advocacy. I think it needs advocacy. I think that the legislature is very attuned to the challenges of family court. More so, I've only been at Niskanen 4.5 years, and even in that short interval, I've seen significant changes in awareness of legislators with the problems in family court. So I think it's possible. I do think there are significant opponents, like the people who serve as forensic evaluators, who don't want to see their role eliminated. I think judges don't want to see that role eliminated. So it's not an easy lift. But there's other things too that we can look at with forensic evaluators. Training. There is no training requirement statewide for forensic evaluators, the psychologists, and social workers who serve as forensic evaluators. There is a bill that passed both the Senate and Assembly in the 2022 session that is on Governor Hochul's desk right now to standardize training in domestic violence, child abuse, and child sexual abuse for all forensic evaluators. Hear, hear, right? Hear, hear. So we are really hoping that she signs that bill. There's a bill to ensure consistently statewide access to the forensic evaluation reports, which some of you who might be practitioners probably are aware that some courtrooms don't allow the parties to have access to the forensic evaluation report, which is hundreds of pages long in some instances. So I know of survivors who have actually been charged by attorneys to sit in that attorney's office to review the report. So they have to pay for the privilege of reading about their family in order to challenge it. That's ridiculous. We should not be treating these reports any differently than any other piece of evidence offered in a case. And there's very sensitive information in the reports, obviously, but there's sensitive information shared in every courtroom. Why are we elevating this one document more than any other? It makes no sense.
One of your proposed pieces of legislation would allow courts to factor domestic violence convictions into the visitation, custody, and parental rights decisions. You need legislation for that?
Well, apparently, apparently, I mean, I think this really does come down to judicial training and judicial accountability, which we talked about this morning, because I think I do question how effective training can be on sensitive issues like domestic violence and implicit bias. Someone has to be receptive to hearing the message in order for training to work, and that's a huge piece of it. But we also need to look at who's doing the training, because every single time someone, an attorney, an advocate, has elevated the need for training, and I've been listening, I hear someone who operates in the court system that says, but we do training. Yes, no one's disputing that the training's happening. What's the training? Because the message isn't getting through. It's just not getting through. So there's lots of legislation to look at in terms of, there's legislation to increase the number of judges in family court in New York City. There's legislation to make sure courts stay open longer in New York City. So through midnight, like up until midnight, which is sort of an interesting proposition. Again, resources, right? Resources. There's also some legislation we're looking at with respect to orders of protection to expand the conditions where you might get an order of protection. There is not currently a bill on coercive control, but we're looking at that. But also just in terms of adding what a judge can put on a condition of an order of protection, like housing costs or the duration of orders of protection. You know, we've lived with these durations for a long time. Maybe it's time to elongate the effectiveness of an order of protection so parties don't have to keep going back to court. The other thing we're taking a really close look at, and I'd be very interested in talking to any of you about this, is the applicability of a law to prohibit abusive litigation in New York State. There is such a law in 2 states that I'm aware of, Washington State and Tennessee. Not typically Tennessee, the state that we look at for innovative legislation. Usually we look at California. But in this case, this is a really interesting law that's in both of those states, which essentially would give the court a protocol for labeling a party as an abusive litigation individual. And that would be if there's a family relationship there. So it has to be a family or household relationship. If the court would have to determine if domestic violence has been perpetrated, which is a little bit of a sticky wicket. So we'll have to look at that. But if those 2 considerations are indeed true, then one party could go to the court and say, I want a hearing because this is abusive litigation. And then the court would have to hold a hearing and take a look at whether the issues in the lawsuit, claim, motion, whatever it is, have they been litigated before in the recent past? Is the filing with the intention of harassing, intimidating, or coercing the other party? Is there a basis in law for an additional prosecution, whatever the prosecution is? And if the court decides none of, that it is harassing, intimidating, and there's no law that justifies the proceeding, then the court can dismiss the case, call it abusive litigation, and then issue an order to say that individual cannot file anything else for a period of time, usually 2 to 3 years. If they do attempt to file, and this is any court, if they do attempt to file, then it goes to the judge first, who ordered, and said this person's an abusive litigation individual. And then the court would have to decide if that claim is valid, if the lawsuit is valid, before it even goes to the victim. The victim wouldn't even see it unless the judge says, yes, this is valid.
So I think we have to stop there, but wait, we're not done. I should have done this in the middle. This was not a best practice. The code for the CLE, for those who are watching, is 4R67HM. That's 4R67HM. I want to thank all the panelists. I just want to make one other point. We talked about additional judges. They did vote these additional judges, but they didn't fund them. They created them, but they didn't fund the judges. So actually, this is going to cost the court system millions of dollars this fiscal year. Hopefully, they'll fund them next year. But where are those millions of dollars going to come from? So we can contemplate that over wine. Thank you all very much.
I just thank you panel. Just a quick announcement. I understand that Gibson Dunn, which is our firm tomorrow, had an email and it was confusing for those who would be going in person tomorrow. I believe that our very own project assistants here filled out all of your forms for you. Yes, Jeannie is nodding. Thank you. And also, by the way, I'd like to acknowledge Jeannie, who is our events coordinator, who has been working very hard. But anyway, so you don't have to fill out a form anymore because we took care of it for you, but you are going to get a QR code. Is that correct? Yes. And so I hope you have one. It should be in your inbox. Yes. Okay. Look in your inbox, see if you have one. If you don't, what do they do? Okay. Oh, you don't have to have the QR code. Okay. Thank you. And for those here, join us for a reception. Everyone else, we look forward to seeing you for day 2, either at Gibson Dunn or online. So have a good night. Thank you.